So the division of the power is done by the constitution, because constitution decides the subject matter division, the jurisdictional division. Each government, whether that is the state governments or central government, is independent in its jurisdiction and does not exercise the rights and the power of the other government. So it will be decided by the constitution that the government, whether that is the central government, does not exercise the right and the power of the state government, and the state government do not, or state governments do not exercise the right and the power of the central government. Thus the power are divided among the various collaborative entities in federalism. So you know that power is divided between different entities, different organization, different bodies, different authorities in the federalism. This power is not assigned to any person, any body, any authority, any organization solely, but the constitution keeps the control on the use of their power by the help of the judiciary. Because the interpreter of the constitution is the judiciary, so the biggest responsibility is on judiciary to keep the constitutionalism intact, to make the spirit of the constitution intact, to keep the constitution from the failure, or save the constitution from failure. So the constitution keeps the control on the use of their powers. And second essential element of federalism is the supremacy of the constitution. The constitution is the source of all power of executive, legislature and judiciary. You know that who is the creator of the executive, legislature and the judiciary? They are not self-created, but they are created by this supreme constitution, so they should keep the supremacy of the constitution intact, because they are the offspring of the constitution. The federal state derives its existence from the constitution, and whenever the executive, legislature or judiciary or government which is created by the constitution does not save itself, they cannot save itself, because they are the offspring of the constitution. So at the one time there may be one sovereign, at the other time there may be other sovereign who may be powerful. With the passage of the time, so the person who will, or the authority who will get power, they will declare itself as powerful entity. So the supremacy of the constitution will be compromised at that juncture, at that stage, and definitely this will frustrate the objective of the rule of law, and might and right will be the motto of the law, which is always dangerous one, which is always anarchist idea, because power go on shifting. So in federal system, the constitution is considered the supreme law of the country, and it defines the power, authority, jurisdiction, function of the government of or the legislature, executive, judiciary, state government, and all other authorities. So all institution functions under the control of the constitution. According to Casey Were, supremacy of the constitution for federal government is very much essential. So for the federal government, where there is the division of the power, there must be the supremacy of the constitution, not the supremacy of the legislature, executive, or the judiciary supremacy. So neither the judiciary nor legislature nor executive should be supreme where there is the federal government. So supremacy of the constitution for federal government is very much essential, and it is also necessary for the smooth working that is must be documented. So it is also very necessary for the smooth working, as you know that if the constitution will be supreme, so legislature, executive, judiciary, or the government or the other authority will function according to the mandate of the constitution. So for the where supremacy of the constitution for the federal government is very much essential, and it is also necessary for the smooth working that it must be documented. So just the constitution should be supreme, the constitution must be documented or written. It is very much essential for the federal government, where there is the two government, center as well as state, and there is the division of the power too, decided by the constitution. So second thing is the constitution, supremacy of the constitution. Third, there is the written constitution. The federal constitution must necessarily be documented. The establishment of the federal state is laid down by complex conditions. So you know that federal state is laid down by the complex condition, complex agreements between the state and the constitution, and that's why the constitution must be documented, because there is the complex condition or rigid condition or just you can say difficult conditions. The condition must be in written form. If it will be in written form, then you can interpret it or the judiciary can interpret it. Otherwise, it would be impossible to keep the supremacy of the constitution intact. Otherwise, it will be very difficult to remain or continue the supremacy of the constitution, because if one want to remain the supremacy of the constitution intact or want to remain, there must be the supremacy of the constitution. The constitution should be written, so it will be documented, it will be evidenced. In case of the written constitution, the central and the state government will get clear understanding of their rights as well as their functions and their duty, power, liabilities, privilege, obligations, etc. So they will get clear understanding of their rights, obligation, duties, function, etc. And you know that fourth essential element of Indian constitution is the rigid constitution, and generally the written constitution are rigid constitution. However, this does not mean that the constitution cannot be amended. Generally, the written constitution are somewhat rigid, because if there is the written constitution, then definitely you will have to interpret it according to its intention, words, or according to the intention of the maker of the constitution. So generally the written constitution are rigid one, because if there is any set intention of the maker of the constitution, you cannot change their intention. You will have to interpret the constitution according to their intention. So the amending procedure is quite complicated and difficult generally. That's why in Indian constitution there is 3 types of the amending procedure. First, amendment by simple majority, and there are certain articles of the constitution that can be amended by simple majority. Amendment by special majority, there are other articles of the constitution which can be amended by special majority. And third procedure of the amendment is special majority plus ratification of more than half states. So this is the third way of the amendment, which is very much complicated one, very much rigid one. So the center or the government who is in power, if want to interpret the provision of the constitution in their favor, they can easily amend the constitution. But some important article of the constitution which generally related to the federalism, basic structure, basic rights, are such which cannot be amended easily, meaning thereby they can be amended by special majority and ratification of more than half states. So the power to amend the constitution should not remain exclusively with either central government or state government. So that the third amending procedure is there is the participation of the central government as well as the state government, and the power to amend the constitution is in the hand of the central government as well as in the hand of the state government, because the ratification of more than half states is required to amend the constitution certain articles. So and second procedure which I told you, that special majority, by the help of the special majority amendment can take place in the constitution. So that also require the 2/3 majority of voters of the parliament or the member of the parliament who are present and voting. So to maintain the supremacy of the constitution, it is necessary to keep the process of the amendment difficult. So if any government want to change this unique structure of the constitution, they can just amend the important article of the constitution very easily to just gain power, to occupy the power, to control the power. But these articles which just disturb the idea of the federalism are in the third amending procedure, which is the special majority plus ratification of more than half a state. So it is also necessary that the procedure of the amendment of the constitution should be very difficult one, so that the constitution could not be amended easily. So third is the authority of the judiciary. It is, the fifth essential element of federalism is the authority of the judiciary. So there is the division of the power between the center and the state governments in federal constitution. And this is very core feature, or this is very core characteristics, that there must be the division of the power in federal constitution, and that this division of the power should be between the center or central government and the state government. How much power can be occupied or controlled by the state government, how much power can be occupied and controlled by the central government. This is the divided by the constitution, this is defined by the constitution, and the division of the power between the two means central government and the state government is done by the written constitution. As I told you earlier, Indian constitution is the written constitution, rigid constitution, and written constitution are generally rigid constitution, and federal constitution are generally written constitution. So therefore it is possible that the different government can interpret provision of the constitution in their favor. So it is possible that different governments can interpret provision of the constitution in their favor. In such a situation, it is necessary to have an institution which can properly interpret the constitution in the fair and free manner. So that it may be that different government interpret the provision of the constitution for their benefit, and if certain different government, meaning thereby the state governments as well as the central government, can define the provision of the constitution or the article of the constitution in their favor, they may interpret it, they can define them according to their own intention, on greedy intentions. So in such a situation, it is very necessary that there must be an independent institution which can properly interpret the constitution in fair and free manner, or just fearless manner, or independent manner, as regards provision of the constitution. Judiciary is empowered to interpret the constitution. So this is the very good thing, that judiciary is empowered to interpret the constitution, and judiciary is empowered to just define the constitution, and it is made independent, it is made free from pressure of the executive as well as legislature. So the interpretation of the constitution by judiciary is binding on all authorities. So this just the interpretation or the definition or just meaning given by the judiciary to the constitution is binding and full and final, and all authorities, all government, all bodies, all organization will respect the judgment of the authority. Though we know that judiciary has not any enforcement power or execution power, that's why we feel that judiciary feels itself somewhat weak, though it is independent, and the transfer or the benefit to the judges cannot be allocated by the government or executive or by legislature. But it is seen that due to the judges are given the post after the post retirement benefit is given, or they are made the chairman or just some big post or human right commission and some other commission. So due to their greed, judges are just tends in a specific area, or they are favoring certain unfavorable thing which is not respectable for the image of the judiciary. So judiciary is independent body, free body, so it should remain its freedom, independency, fearlessness. Though the judiciary is not given the executive power, certain executive power should be assigned to the judiciary, in my opinion. Otherwise, it will be very difficult to remain the independence of the judiciary intact. So all the essential element, which was 5: division of the power, supremacy of the constitution, written constitution, rigid constitution, and freedom of the judiciary or authority of the judiciary are over here in Indian constitution. That's why we say Indian constitution is a federal constitution, because these are all essential element of the federal constitution, which was mentioned above, exists in Indian constitution too. Few constitutionalists have opined that Indian constitution is not federal state in its true meaning. The critics of the Indian constitution give following reasons, which we will discuss later.